Buffalo and why attorneys for the white supremacist gunman who killed 10 black people at a Buffalo supermarket told a judge Thursday that the federal charges against him should be dropped because there weren't enough black people and other minority groups on the grand jury that indicted him. Peyton Gendron did not attend the hearing, during which his lawyers argued that his constitutional rights to a grand jury drawn from a cross-section of the community were violated. At the hearing start, U.S. District Judge Lawrence Villardo noted Gendron's objection to the prevalence of white people on the panel seemed a little incongruent in the hate crimes case. He did not immediately rule on the motion. Gendron could face the death penalty if convicted in the 2022 mass shooting at a top supermarket, which he targeted because of its location in a primarily black neighborhood. Those killed ranged in age from 32 to 86. 3 others were wounded. Gendron already is serving a sentence of life in prison without the possibility of parole after pleading guilty in November 2022 to multiple state charges, including murder. A trial on the pending federal hate crime and weapons counts is expected to begin next year. The Justice Department said it would seek the death penalty if Gendron is found guilty. Attorney John Elmore, who represents some of the victims' relatives in lawsuits, said Gendron's lawyers are doing what they can to keep him alive. He said challenges to the makeup of juries rarely succeed, even though he regularly sees juries lacking minorities. It is very ironic that attention to this problem is being brought out in this case, where Peyton Gendron committed a racially motivated homicide, he said by phone after the hearing. Gendron's lawyers argued in a court filing that black and Hispanic people and men are systemically and significantly underrepresented in the list from which jurors are selected in the Buffalo area. To illustrate this point, the grand jury that indicted Peyton Gendron was drawn from a pool from which approximately 1/3 of the black persons expected and 1/3 of the Hispanic Latino persons expected. Gendron's lawyers wrote, "Exacerbating the problem," they said, was that the data sources used by a vendor to pull the list together weren't preserved. "We don't know what the vendor did," Assistant Public Defender Sonia Zoglin said. "More importantly, the vendor doesn't know what he did." Statistically, the addition of 2 more black people on the 60-person grand jury panel would have balanced the panel, Villardo said. "Can't that be the result of an accident?" the judge asked, rather than systemic exclusion? In opposing the motion, Assistant U.S. Attorney Caitlin Higgins said that issue constitutes a technical violation, not grounds to dismiss the indictment. The federal law governing jury selection doesn't entitle the defendant to a perfect representation, she said. Zoglin said the issue was larger than the panel that ultimately heard Gendron's case and included the exclusion of certain groups from the selection process, including inactive voters. In a written filing, the U.S. Attorney's Office said Gendron didn't prove a systematic underrepresentation that was caused by the district's jury plan. Any disparities in the racial makeup were within accepted guidance and not caused by the selection process, which draws from voter, driver, tax, disability, and unemployment roles. Higgins said courts have routinely rejected similar challenges. Villardo said he was unaware that any such motions had been granted in cases with similar disparities in New York State's federal courts. Gendron's attorneys, in an earlier filing, argued that Gendron should be exempt from the death penalty because he was 18 years old at the time of the shooting, an age when the brain is still developing. That motion is pending.